District of the State of Florida is now in session. The Honorable James A. Edwards, Chief Judge, presiding. All persons having business before this court draw near, give attention, you will be heard. In God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning, everybody. Welcome to a session of oral argument before the 5th DCA. I've already been introduced. To my right is Judge Makar, and to my left is Judge Kilbane. We have 2 cases on our in-person oral argument docket, and 1 for later on. If you have any noisemakers, please put them in the silent mode or vibrate. You don't need to turn them all the way off, but they'll come on at the worst possible time, so just be aware of that. Our system here is very easy. Green means you still have plenty of time. Yellow for the appellant means you're into your rebuttal time, and red for both sides means stop. For the appellant, we typically reserve 5 minutes. If you want something different, just let me know, and we will take care of that. So without further ado, we will have case 23-1194, R1CS2 LLC versus FDOT and Circle K stores.
Good morning. May it please the court, Rachel Cruz with Gray Robinson on behalf of the appellant fee owner R1. There is no statutory authority to apportion a fee award. Circle K is asking this court to create new law, a new apportionment right, unauthorized by statute. The eminent domain apportionment statute, which is 73.101, was enacted in 1965. It doesn't mention fees at all. It's never been amended, yet until now, no court has ever authorized the apportionment of an attorney's fee. But that's what Circle K relies on, the 65 statute, to suggest that the court can do this. The legislature limited apportionment to the, quote, amount awarded. And they weren't talking about attorney's fees when they said amount awarded. The amount awarded relates back to the amount found by the verdict of the jury, which is compensation for land, business damages, severance damages, moving costs under 73081. It's not attorney's fees. And this was intentional. The legislature enacted the apportionment statute, .101, and the jury verdict statute, .801, together in 1965. And in 65, it purposefully segregated fees from the underlying compensation and what a jury would award. Before this, the jury did determine and award attorney fees. So in 65, the legislature purposely changed that, took out attorney's fees from the amount awarded. Likewise, if you look at the first offer statute, which is 73.015, and that's from which you calculate the benefit-based fee, purposefully, it is the exact same thing that a jury awards. It's not fees. Fees aren't part of the amount awarded by the jury. They're not part of the first offer, and they're not apportioned. And the legislature couldn't have been thinking about the benefit-based fee back in 65 when it enacted the apportionment statute, because we don't even see 73092 until 1976. And we don't see the benefit-based fee mandated until about 30 years later in 1994. The problem here is Circle K and the trial court completely ignore the purposeful interplay between the betterment fee calculation that you find in 0921 and the first offers in 73.015. The legislature purposely tied these things together in 1999. They reference each other. They're inextricably intertwined.
Counsel, if you could walk me through. So this 73015, it talks about business owners, does it not?
Yes, ma'am.
And it explicitly talks about their rights in certain circumstances under 73.092, does it not?
Correct.
So is your argument that it never can apply to them, or how does it apply? I guess if you could clarify that.
Absolutely. So the first offer statute, subsection 1, deals only with fee owners. And
how do you make that assertion?
Because it says fee owner about 10 times in subsection 1. So clearly,
I'm sorry. Are we talking about subsection 1 of 015 or 092?
015.
Okay.
The first offer statute, right? Okay. So that subsection 1 applies to the fee owner, and only the fee owner gets a betterment fee for the underlying compensation. Subsection 2 of the first offer statute relates to the first offers made to business damage, business owners. And they also get a benefit-based fee based on the business damages, but that's completely separate. They do not get a business or a benefit-based fee for anything under subsection 1, because that's all fee owner. Does that clarify?
For now, it references in subsection 4, again, the ability of the business owner in certain circumstances, let's say 4B, to take under the 0921.
Correct. Yeah, absolutely. The business owners always get betterment fees, or they're entitled to benefit-based fees under subsection 2. But that is completely separate. They get a separate offer for their business damages, and they get their separate benefit-based fee. But the fee owner gets its own first offer and their own betterment fee, which is complete. Those two buckets are completely separate.
Understood. And with respect to that, if I could, I noted in your brief and below that the initial offer to your client was $94,100, correct?
Correct.
I didn't see anywhere where there was essentially a calculation as to how this $76,197 came to be, because that's really what we're talking about here, is it not?
Yes.
So where did that number come from in this case? I understand what you're saying, that typically it's two buckets, and that would make sense, that they can't take from each other. But where did it come from in this case? Where was that number?
Sure. So it's based on the final judgment, and the final judgment is for the thing that a jury would award: land compensation, severance damages, that sort of thing. And the final judgment was $325,000, and so it's 33% of that betterment. So the difference between the $94,000 first offer and the ultimate final judgment, that's how the $76,000 got calculated. Now the business damages were separate. So the business damage, or the let's say Circle K here, they got their own first offer under the business damage statute. So, and then they got a betterment of that. They did good on their business damages, so they got paid a separate benefit-based fee for the business damages portions. But the business damages were not at all part of the fee that we're talking about, the $76,000 at issue.
Okay.
So for better or worse, the legislature crafted the eminent domain scheme that we have today. Again, under 0921, benefit-based fees are awarded to, number 1, attorneys representing fee owners, and number 2, attorneys representing business owners. And in each case, those calculations are tied back to the first offers that each of those get separately. All other fees that are allowable are under subsection 2 on a lodestar type basis. But let me be clear, make no mistake, if this court does not correct the trial court error here, it will cause a sea change in eminent domain litigation. It will open a floodgate of fee litigation. Creating this new apportionment right is going to create what I call betterment theater. It is going to incentivize every attorney in an eminent domain case to over-litigate claims, to manufacture records, to show that, hey, I'm the one who got all of these compensation increases. You're going to see everybody fighting the order of taking all of a sudden. You're going to see discovery issued that never would have been issued before. You're going to see people filing as much paper as they can to show that, hey, I'm the hero of this case. I got the compensation here. And the DOT is going to have to pay for all of that, or the taking authority. They have to.
Why does the DOT have to pay? As they put it, they have no dog in the fight. What is FDOT's role in this appeal, if any?
Yes, Your Honor, great question.
Thank you.
First of all, at the lower court level, it is undisputed by anybody. They certainly have to pay for apportionment battles at the lower court level. That would include apportionment fights over the fee. On appeal, they've made a different argument, but that's appellate fees, which are somewhat separate. But even setting aside the attorney's fees that they'll have to pay for these sort of food fights that are going to happen, what's worse, what's going to be even more expensive, is they're going to have to pay for all the expert teams that all of these attorneys are going to hire. So they're going to put together an expert team to not only deal with their little piece of the pie or their little piece of the case.
If the parties agreed to the land value, the parties agreed to what the attorney's fees ought to be. At that point, why isn't FDOT done with it? Because at that point, the parties have been paid full compensation. It's just a question of who gets what part.
You're right. And so DOT has been very, very careful to say that they don't have a dog in this fight based on this record. And they're right, because and this record will not be what you see again. Look, the state of the law when this took place below, when these proceedings happened, was that you don't get the betterment fee. It only goes to the fee owner. That was the case for 58 years. Perhaps naively, the trial counsel here for the landlord wasn't super concerned about it. And I think that's why DOT is not up here with me. So early on, there was settlement. There was settlement of all the fees and costs below for the below proceedings. You won't see that again. And the reason DOT doesn't have a dog in the fight is because of those early settlements. But I think the most important thing the DOT has said in this case, and they haven't said much, but if you look at their fee response on page 9, footnote 1, they know this is bad. And this is what they wrote, talking about not having a dog in the fight on this record. They, and I quote, "This view may change if the trial court's innovation of apportioning the statutory benefit fee becomes widespread and fee disputes at the circuit court level proliferate as a result." FDOT knows this is a new right the trial court came up with, and they know this will be a problem on a going forward basis. They might not have a dog in the fight based on this limited record, but they are concerned. The taking authority, again, will have to pay for the attorneys to put on this betterment fee. And look, in a case like this, it doesn't seem like a big deal. You've got one lessee attorney, one fee owner attorney. But in a big case, it's going to be a big problem. As an example, my team had a case a couple of years ago.
Is this in the record?
No, this is just a hypothetical.
Well, let's stick to the record and what's been argued in the brief, okay?
Well, sure, but what I'm saying is that it could be a very expensive problem. So what if you have a case where there was a huge betterment fee, say $10 million, and you have one landlord and 24 tenants, okay? The fee litigation that would take place, the cost that would be incurred by the taking authority to fund these fights among 24.
Well, counsel, those all sound like policy arguments, and we need to look at the statute. And also, if you could address the contractual issue you raised on appeal.
Sure. Well, the statutory text is clear, and I think clearly on our side. This is something that the trial court came up with by itself, really, kind of innovated a right that does not exist under statute. Turning to the
main issue you brought up, the first issue, was the contract, right?
Sure. Under the lease, I find it incredible that the lower court here thought that the lease was helpful to Circle K. If you read it, it's very favorable to the landlord. It says you literally get everything. You get all the eminent domain compensation, save these few exceptions. And among those exceptions, no attorney's fee, certainly not the betterment fee that statutorily the owner gets. So I submit what Circle K is really trying to do here is have this court or the lower court give them more than they bargained for in their lease. You know, they could have changed those lease terms. They could have asked for more in the lease. They could have bargained for that.
Did y'all put anything in the record below in writing, some memo in response to the contractual issue? You argued that there was a hearing, there was an argument, and there was some limited argument about the nature of the contract scope. But was there any memo of law or any type of legal document that y'all filed?
At the lower court level about the lease?
Right.
I believe so. I believe in our, in arguments made below, part of our argument was this statutorily isn't authorized, and B, that's not what the lease says. We went under the lease.
Well, but counsel, let me ask you this. It looked to me like below, y'all argued that the lease does not provide for attorney's fees to the tenant, and on appeal you're arguing that the lease prohibits payment of attorney's fees to the tenant. In other words, the tenant included part of Section 15.1 below. Y'all didn't present the rest of it. You didn't argue about the rest of it. Now on appeal, you are arguing about the rest of it, which arguably could prohibit it. But was that really discussed with the trial court? And if so, where in the record, where in any hearing transcript did y'all discuss the prohibition aspect of the lease?
I believe that was in the briefing and in the argument made at the...
When you get back up on rebuttal, you can point
Yes,
us
sir.
to the proper pages where that specific argument is made, because you did discuss the lease below. I don't doubt that, but those are two different arguments under the lease.
And- and maybe I didn't understand your question.
Sure,
then.
I'll repeat it. Below, the argument was the lease doesn't provide for payment to the tenant. In other words, there's not a section in there saying tenant gets to share in the attorney's fees.
Correct.
On appeal, you're saying the lease specifically prohibits any money to the tenant other than these 4 exceptions or 5 exceptions under 15.1. So,
Okay, so there are 2 separate attorney fee provisions in the lease, and 15.1 deals specifically with condemnation and what you get in a condemnation.
24.1 or whatever it is prevailing party for enforcing
Correct.
or dealing with a breach. Yes.
Yes, Your Honor. And so the idea that an owner would have to come out of pocket to pay for any part of
The idea that you're making an argument on appeal that I'm not sure you made below is a concern. So that's why I'm saying you can get up. I mean, you can address it now if you want to, or you can take the time to look into that while you're waiting for your rebuttal.
Okay. I'll look at the record. I want to spend a moment on, the record below, because I think that what Circle K is asking this court to do is to make bad law based on bad facts. And the record didn't come to this court in the best position, but attorneys, this isn't going to be an issue going forward. Attorneys don't like to leave money on the table, and the way the legislature set up this fee schedule is that the attorney is incentivized to get every single dollar that it can bring in for the entire pot, which benefits everybody. It benefits the fee owner client, it benefits the lessee, it benefits the attorney. That's the scheme that the legislator set up, for better or worse. And, I don't want the court to be, led into error because, that R1 didn't do the best job on communication, but I think Circle K exaggerates what they did below and minimizes what the fee owner attorney did below purposefully. But, for example, the order of taking and the good faith deposit, that's not important. It wasn't tied to value. That wasn't something. That's a kind of betterment theater I think you'll see if this gets proliferated. What really mattered in this case was R1's work to get the variance to do a title issue. They had more hours in the case.
They got specific fees for the variance, didn't they? $6,000?
Yes, Your Honor. That was paid separately. And then the other huge deal that had to be resolved was a TIF issue, a title issue. And that had to be resolved as well. I didn't get to say a lot of what I wanted to say, but I'm into my rebuttal time if I may reserve.
That's fine. One second while I get your game clock right here. Okay.
Good morning, Your Honor. May it please the court. Lindsay Lopez on behalf of the appellee Circle K, and we're asking you to affirm, because we believe the terms of the lease, the language of Chapter 73, and the evidence that was presented to the trial court all support the apportionment award here. And RICS 2's argument appears to be that they received the initial offer and that they negotiated the ultimate settlement on compensation, and as a result, RICS 2's attorney is responsible for the entire statutory benefit here, and that is simply not supported by the record in this case. It is undisputed that Circle K had a written lease with a 60-year term. It's a triple net lease, which means that Circle K was responsible for everything to do with the property, all the maintenance, all the fees. Ultimately, the parties settled and determined that Circle K was entitled to, excuse me, I'm getting a real cold, 57.38% of the total amount awarded. So the parties agreed that Circle K was the party that had the greater sort of beneficial interest in this property. And so Circle K really took the lead throughout on establishing the increased value of this property. And Section 15 of the lease, we've talked about a lot, specifically relates to condemnation. And in this case, the parties agreed, they had a contractual agreement, that Circle K and RICS 2 could each represent themselves before the condemning authority, and they would each be entitled to any amount awarded or apportioned to them. And RICS 2 in the briefing says, well, there's 5 specific areas all the condemnation award will go to the landlord except for these 5 specific areas. Importantly, one of those areas is 15.14. This is in the record at 932. It says the tenant is entitled to any portion of the award attributable to the unexpired portion of the tenant's interest in the leasehold estate created by this lease. And in this case, the statutory benefit fee is calculated based on the difference between the initial offer and the final judgment. And 57.38% of that final judgment amount was attributable to Circle K's interest in the leasehold estate created by this lease. And so that's a benefit that was achieved by Circle K. The statutory benefit fee that flows from the amount that was awarded to Circle K is a benefit attributed to their portion of the leasehold interest. And the undisputed...
it would have been better if the lease had said, clearer, let's say, in this sense, it would have been clearer if it had said that the tenant's not entitled to a share in the statutory benefit fee.
Right. If that was what the parties intended,
but at the same time, it gives exceptions, and the statutory benefit fee is not one of them.
That's correct, although the statutory benefit fee flows directly from the leasehold interest, just like the portion 15.13 that gives the tenant a right to any damage or loss to the tenant's business or goodwill. That doesn't say that Circle K is also entitled to the attorney's fees associated with the business damages, but no one has ever disputed that it is, because that is part of the overall compensation. And that's really, there are, I'll say, 4 really important legal concepts here.
But it's really 15.14 that you're relying upon.
The 15.14 is what I'm relying upon, but I'm just pointing out that 15.13 is what is a totally separate right to business damages, and that section also doesn't say that Circle K is entitled to the attorney's fees associated with proving its business damages, but it's never been disputed that that's sort of part and parcel, and that is Florida eminent domain law. That's what multiple courts have found are the constitutional rights of an owner. So I'd say there are 4 really important legal concepts here. First
on this issue, the contractual issue, are you contending that they have not properly preserved the issue for appeal?
Your Honor, I have to admit that I heard that question earlier. I don't remember. Whether
in your appellate filings, have you contested that it was properly? Okay.
I don't believe we have. So the first important legal issue here is that Florida landowners have an express constitutional right to full compensation for any property that's taken by the government. This is Florida Constitution Article 10, Section 6A. The second is that a lessee of property under a written lease is considered an owner who is entitled to full compensation. The Florida Supreme Court discussed this in the Carter case that we cited. This court discussed it fairly extensively in Tuscan Ridge. And the Trump Enterprises case from the 4th DCA is really important under the facts of this case because it discusses that there is a difference between business damages. Lessees are not limited to business damages. They are also entitled to be compensated for the taking of property that they're leasing. In the Trump Enterprises case, it was like a public shopping center, and there was a restaurant that was being operated out of part of it, and there was a taking of a grassy strip of like 500 feet that was part of the lease premises, and the court said, well, it didn't really affect your business. You're not entitled to any compensation for that because it doesn't infringe on the restaurant. It doesn't impact your business in any way. And the court said, it doesn't matter. Business damages is a separate issue from the taking. And lessees are entitled to be compensated not just for business damages, but also entitled to be fully compensated for the taking. And third, full compensation under the Florida Constitution includes the right to a reasonable attorney's fee. And the Florida Supreme Court discussed this in the Door Trust case that we've cited. And I'm not going to quote extensively, but it has some really important language here. It says, in Florida eminent domain proceedings, the goal is to render the private property owner as whole as possible because the owner of private property sought to be condemned is forced into court by one to whom he owes no obligation, and it cannot be said that he has received just compensation for his property if he is compelled to pay out of his own pocket expenses of establishing the fair value of the property, which expenses in some cases could conceivably exceed such value. So in this case, Circle K had a right under its lease to represent itself in the condemnation proceedings. And it did represent itself. We have a pretty extensive record here, but it's very clear that Circle K's lawyer took the lead in the litigation here, and that's probably because Circle K had the bigger stake in the property. Circle K was the one who was responsible, who was really operating on the property, was responsible for all the expenses of the property. And so counsel from the start, when the initial offer came out, now this was before the landlord retained counsel, but when the initial offer came out from DOT, the landlord said, as the landlord was required to do under the lease, gave notice to Circle K and said, we're going to take this unless you object. And Circle K said, yes, we object. We're going to hire our own appraiser to protect our interest in the property. And that's what Circle K did.
Well, counsel, with respect to that initial offer, that $94,100, was that made to both Circle K and the property owner in this case?
It was addressed just to the property owner, but it clearly included Circle K's interest. It shows on the offer that the interest in the property is subject to this lease, and so it's the undivided fee, the full fee rule in Florida that says that the condemning authority only has to make one offer. The condemning authority doesn't have to get into questioning what each owner's interest is in the property. They make a single offer and it's addressed to the fee owner, but so the value of the property is determined, and then in supplemental proceedings, the court, in this case the parties reached an agreement, but in supplemental proceedings the court apportions the interest. But it was for the entire property, and on its face it included Circle K's leasehold interest, and Circle K was then named as a defendant in the eminent domain complaint. And so there's no doubt that Circle K's interest was always at issue here, was always of record here, and that the landlord, under the terms of its lease and based on the fact that Circle K was a defendant in the lawsuit, could not have just settled it on its own. It required Circle K to participate and to...
There was evidence presented to the trial court about which attorney did what for his or her clients, correct?
Extensive
And
evidence.
Based on that, I guess the judge made some kind of conclusions. Does the judge actually come forward and say, I find that Circle K's attorneys did more or were accountable for this percentage of the increase while the owner's attorneys are responsible for 0 or 20% or whatever?
No, Your Honor, I don't think that the order does that. I think that the order lays out what each side's argument is, and then ultimately apportions the award consistent with the apportionment of the underlying statutory benefit, which is consistent with 73.092, which says that the fees should be based solely on the benefit achieved for the client. And so the court just said, well, this is the benefit achieved, and your portion of it is 57.38, and yours is 42.6 something. And so it's tied to the statutory structure. The court doesn't lay out its analysis. Instead, it lays out what each of the parties argued, and then...
It's based on benefit, not hours put in or billable rate or anything else. It's based on what benefit did you get for your client.
Right. It was based on the benefit achieved for the client. And I know that obviously the landlord's position is that there is nothing in the statute that says that the fees can be apportioned. There's nothing in 730.092 that says that the fees can be apportioned. I would just ask the court to take a look at that statute, because there's also nothing that says that they can't. There's nothing in that statute that says that these are fees that are strictly for the fee owner, which is in contrast to the 730.015, which extensively discusses fee owner. 730.092 says, the court in eminent domain proceedings shall award attorney's fees based solely on the benefits achieved for the client. The court had meant to say that this should be based solely on the benefit achieved by the fee owner. It could have said that. We certainly know they know how to distinguish between fee owners. And the offer going to the fee owner is consistent with the undivided fee rule, but this clearly says it's for the benefits achieved by the client. The 4th DCA discussed this concept a little in the School Board of Palm Beach County case that we've cited. That case is different in some important ways, but it's really instructive. In that case, there was a eminent domain proceeding. Most of the compensation went to relocate the tenants, a lot of expenses that went to the tenants who were on that property. The fee owner came back in and requested and obtained a fee award that was based on the entire benefit that was paid for the property, and the 4th DCA looked at it and said, no, you can't be compensated based on a benefit that was achieved for the tenants, because the tenants were not your client. The fee owner was your client. And so you're not entitled to any statutory benefit fee based on benefits that were not achieved for your client. Now, in that case, there still were no fees paid to the tenant, but it's because the court does not find that tenants are not entitled to fees. Instead, what the court finds is there was a final judgment that said you wouldn't get any attorney's fees. That was never contested. There was no motion for rehearing. There was no appeal. And so now that issue is final and it can't be challenged. But the fee owner is not entitled to a statutory benefit fee that includes compensation that went to the tenants. And that's just what RICS 2 is arguing for here. And they say over and over again that this court would be making new law if they agreed and affirmed the trial court's award here. But the truth is there isn't law on this. Either way, the court is going to be weighing in on a situation where there is no district court decision that resolves this issue.
Counsel, I want to take you to the stipulated final judgment. There was a lot of discussion about this at the hearing, the apportionment hearing, and subsection 7 of this agreement, it does seem like an issue of first impression, but subsection 7 talks about this $76,197 for the statutory benefit attorney's fees as to parcel 117. Said sums are the contested settlement funds which are subject to apportionment.
Yes, Your Honor, we think that...
Does that have any implications here?
Well, we certainly think that the parties understood that these fees were subject to apportionment. It's been our position throughout that the fees are subject to apportionment. I will say, I believe the landlord has always argued that they should not be apportioned, but we believe that throughout the proceeding, we've certainly always advanced that these fees were subject to apportionment and that that's reflected in the final judgment there.
And one other question with respect to the offers made. Was there ever a counteroffer made regarding the business damages?
Regarding the business damages,
well, looking at the statutory scheme, it does seem that the initial offer is typically made to a single person, but if there are subsequent business damage issues, that the portions of 73092A1 and 2, which are referring to business damages, speaks to final judgment or settlement or written counteroffer. So
this, I don't know exactly. I believe that the issue of business damages was completely separately litigated. It was kind of a totally separate path and a separate pot of damages. That because Circle K was the only entity operating a business on those premises, there's never been a dispute that Circle K was entitled to those. That issue was settled. There were experts that were retained, and there was negotiation back and forth between FDOT and Circle K. So there was an initial offer made to Circle K related only to business damages, not related to its interest in the leased property, not the taking of the property. And that issue was ultimately resolved between counsel for FDOT and counsel for Circle K.
Let me ask you about your motion for appellate attorney's fees. That's based on section 24.1 of the lease, is that right?
It is.
And that provides for attorney's fees for the prevailing party to be paid by the losing party for enforcement of the lease or for dealing with a breach of the lease. Is that correct?
Yes, Your Honor.
And is this a breach of the lease or an enforcement of the lease action?
This is an enforcement of the lease. This is an enforcement of Circle K's right to receive the amounts that it's entitled attributable to its leasehold interest in the property.
And that's based on section 15 of the lease?
Section 15 of the lease, specifically section 15.1.4. So we are trying to enforce our rights to be fully compensated and to receive the portion of the condemnation proceeds that we're seeking. And so that's the basis for our motion for attorneys.
You're not seeking fees from FDOT, are you?
We are not. No, we don't think that would be appropriate under the DAMA case. So.
Do you see the floodgates opening as appellant's counsel has cautioned?
I don't think that's really a significant concern here, Your Honor. These are Because of the statutory scheme here, they're essentially contingency fee lawyers. And contingency fee lawyers are always motivated, or frequently motivated, I should say, to resolve a case as expeditiously as possible, because there is no additional upside. If you're not achieving an additional benefit for your client, there's no upside in over-litigating it. Perhaps you would have additional expert fees, but I can't see that attorneys would over-litigate an issue just for the purpose of paying a third-party expert. And I know that the counsel said that, sometimes these cases can get really complicated, and there could be multiple lessees, and there could be multiple lien holders, and all these things would have to be apportioned. That's just what has to happen already with the underlying award. Those things already have to be apportioned, and they could be complicated, but apportionment is the framework under eminent domain proceedings. I would say that the bigger concern I see is what we believe happened in this case, which is that you have a fee owner who has a less significant beneficial interest in the property, so they are less motivated to pursue the claim, less motivated to put in the time themselves to do all the work for establishing the increased value. And so they sit back and allow the tenant to do the work of increasing the value of or establishing the increased value of the property. And then they say that solely by virtue of being the fee owner of property, they're entitled to the entire statutory benefit fee when that statutory benefit was achieved by another owner.
But is the apportionment of the property value, the ultimate property value, in this case, let's say the $325,000, is that a portion based on attorney effort?
No.
Or okay.
No, absolutely not.
Right.
But I think that just in the fee flows from the benefit obtained, so I believe the apportionment could be, if you're apportioning the benefit obtained, then the portion of the attorney's fees, I believe, would be similar.
Well, if we have one owner and 24 tenants, as we were previously discussing, and one of those tenants has a real fire, and their attorney gets does all the work, they're not going to get all of, let's say the property's worth $10 million. They're not going to get $9 million of that, are they, just because they did all the effort?
I would say...
Now, and I'm not talking about the statutory fee. I'm talking about the value of the property.
No, absolutely not. No, you're correct. It's going to be apportioned based on their interest in the property. I agree with that.
Can I ask you a quick question? On 15.1, it's entitled Condemnation Damages. You're not arguing that attorney's fees don't fall within that, are you?
No.
Okay. So your damages includes attorney's fees?
I think that the attorney's fees under the case law, it's very clear that the full compensation under the Florida Constitution includes the attorney's fees.
But under the contract.
Oh.
Because the contract it has a damages area that has a fees area, but you're not arguing that fees don't fall under here.
No, I'm arguing that the fees are necessarily part of the damages, because the fees are to be fully compensated for your interest in the property.
And my quick follow-up question, I know you're running out of time, is you're relying on 15.14, but I don't see it cited in your brief in support of this argument.
I believe it is cited in the brief. I can take
well, it is or it is. Maybe I just missed it. But
I'm virtually positive it is.
Okay. It seemed like you were focusing more on that one sentence in 15.1 than the remainder of the 15.1.
I'm not. I believe it is, but I couldn't say for sure.
All right. Thank you.
Thank you. I did have an opportunity to look at the transcript, and I do believe the issue was preserved at page 1030 of the record and 1111 of the record, where counsel for R1 said that the lease did not entitle Circle K to any attorney's fees. One of the problems here that may not be so easy to see is that you can never tell how much benefit a lessee ever gets for their client. Here, maybe it looks like Circle K got a benefit, or the attorney got a benefit for Circle K. He could have taken them negative. We have no idea, because it's a unified first offer that isn't broken out. So what if in the DOT's mind, if they'd broken out the interest, they would have said, DOT believes R1 should get 10% of the compensation and Circle K should get 90% of the compensation. That might be how they broke it out. Well, they only got 57% of the compensation. So it's possible that they went backwards, that they went negative. If you don't have a first offer under .015, you don't know where you start. And if you don't know where you start, you have no idea whether there was a benefit for that client or backward.
The party stipulated to it. You're talking about another case.
No,
right?
no.
In terms of how to apportion the betterment,
Correct.
the increase, wasn't that agreed to between the parties?
Yes, Your Honor, and importantly, it was agreed to because of lease terms, not because of attorney effort. Attorney effort has nothing to do with how much, a landowner gets.
Right, it's all about how
versus a tenant.
much the client has benefited, but when you look at the apportionment, why wouldn't that demonstrate a benefit to the tenant?
Because it literally could have been a negative. You don't know because you don't know how much of that offer they were supposed to get to start with. Maybe they should have gotten 80%, not 57%.
Did
you
y'all
don't know
argue in your brief that they went backwards or may have gone backwards?
No, I mean, it's just part of, the not being practically able to do that. It's tied to the first offer. The whole point is if you don't have a first offer, you don't know whether you got a benefit or not. The fee owner's attorney does, because the fee owner, for every dollar that they bring in, the bigger the pot, the better for everybody, and that's what the legislature did. There's nowhere in Chapter 73 where the legislature contemplates having a bunch of mini trials for betterment fees. It's just not there. It's not what was intended. They incentivize the fee owner to bring in every dollar for all of the buckets of interest, and only after that does the judge apportion what a jury would normally award.
The legislature could have made it clear and just said you can't do this.
I'm sorry?
The legislature could have made it clear, but they didn't.
Well, I think they did make it very clear because they didn't allow for any first offers to be made to lessees. They don't get a first offer. Their interests are not segregated out. I want to spend just a moment to talk about the school board case because it's completely in a posit. It has no place to be considered here. That involved federal relocation monies. Because of that, it's not part of the first offer. It's not part of the bundle of sticks. Getting more relocation money could never be a benefit to the fee owner, to anyone, because it's a separate federal program. And finally, with regard to the argument that the landlord could somehow be forced to come out of pocket in an eminent domain case because of 24.1, I believe that to allow DOT to avoid its statutory obligation to pay reasonable appellate fees to everybody is one thing, but forcing a fee owner to come out of pocket to defend its constitutional rights would be unconstitutional and punitive. This is an in rem action brought by the DOT. This is not an action to enforce the lease. This is not an action on breach of the lease. This is an in rem proceeding that was brought by DOT, and the only reason we're here is because of an action brought by DOT. Again, I can assure you, this will open a floodgate of litigation. This will change the eminent domain landscape. And, this would be an authorization of something that's never been done before. I have 5 seconds. I will ask this court to please review the Alachua County order because it's spot on at the record from 510 to 518.
And there's another trial court order going the other way, correct?
Well, not really, Your Honor, because that was not litigated. That was the same attorney, and it was just an agreed order where it was not briefed and the judge did not decide that issue.
Thank you. All right. Y'all are excused, and we'll take the next case.